Welcome to the Probate Nation. Probate is a process to transfer the title of probate assets to the beneficiary of the decedent. As we have learned in prior shows, not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on one of those slow-moving steam engine trains, probate of an estate has a beginning and several stops along the way. At the end of the probate journey, the balance of the probate assets remaining on the train are unloaded and delivered to the decedent's rightful beneficiaries under the terms of her will, or if it has no will, the laws of intestate succession. Today's show focuses on steps an executor may need to take to identify those rightful beneficiaries, and if they are unable to do so, what they should do with the unclaimed inheritance and what happens to that inheritance once it's turned over to the Commonwealth of Virginia. Our guests tonight are two Virginia attorneys who face these challenges each day in the course of their law practices. They will serve as our guide in discussing what needs to be done, when, and why, so you deliver the estate asset to the rightful beneficiaries of the estate you are probating. Our first guest is the founder and owner of the Bromley Law Firm in Fairfax City. His practice focuses on trust and estate litigation. He previously served as co-chair of the Wills, Trust, and Estate section of the Fairfax Bar Association. Prior to going into private practice, he clerked for Fairfax Commissioner of Accounts, Jack Rust. Our second guest is a partner in the Mid-Atlantic law firm of Whiteford, Taylor, and Preston. Her practice focuses on areas of estate planning, estate administration, and trust and estate litigation in Metro DC jurisdictions. She's a member of the Trust and Estate section of the Virginia State Bar, the Maryland State Bar, the District of Columbia Bar, and the American Bar Association. She's also a member of the Advisory Council for the Hospice of the Chesapeake. Please join me in welcoming attorneys Mary Ellen Willman and Jonathan Bromley. Guys, thanks for coming by today.
Thanks so much, Richard.
Thank you for having us on, Richard.
Oh, it's a pleasure. And thanks for coming back, Jonathan. You had a good time last time you were here.
Apparently I did something okay. Thank you, Richard.
You're very welcome. Well, our topic today is Virginia unknown heirs and unclaimed property. So the first thing that comes to mind is at the very beginning of the estate process, when you go to qualify, you have to complete this list of heirs form. Tell us a little bit about that.
Yes, well, when you qualify a probate, they're asking for lots of different types of estimates. One of those, of course, as you've covered in other shows, is the value of this estate. But they're also looking for an idea of who the natural heirs of this person are. You know, and an heir is a person who would inherit an estate had there not been a will. So one of the things you're going to have to tell the court when you qualify and become the executor or the administrator is who are the people that have natural rights as to this estate? Who are the heirs at law?
Sure. And that form, which we will not necessarily, we're going to show on screen to our viewers, it has a spot where we have to list the name of the heirs, their addresses, and relationships. So obviously you walk into the probate office and you might not know that. Okay, so what do you do if you don't know who those people are?
Well, clearly you want to make some attempt to try to figure out who it is, because it's really going to save you some effort in the long run. But to the extent you come to probate and you still don't know that there are any heirs at all, or there's a line of family members who you may not be as familiar with, you would identify that for the court when you qualify, and you would list them as basically heirs unknown, or that certain heirs are still unknown at that time.
Okay. And if we don't know it, then we can come back to it and we can amend the list of heirs at a later time.
The court will allow you to amend it. You know, I would typically recommend, you know, not to amend it every few weeks, every time you find somebody else, and maybe wait till you've gone further in the process before amending. But yeah, there's no rule against amending the list of heirs at a later date if you're not quite sure who they are when you start.
So knowing those people also then sort of follows its way as we turn to once you've been qualified, you have to give notice to these people who might be heirs if there were no will. Okay, and so there's a special form in which you actually do this. So what's the purpose behind giving that notice, though, Mary Ellen?
Well, the notice is to give formal notice that an estate has been opened and that a administrator has qualified, and it informs the certain people who are required to receive this notice that the estate is there and they have certain rights in the estate in order to perfect those rights.
Okay. So the most challenging part then, once again, on this particular form is, I know that we're showing this on our screen, is number 6, where we actually have to indicate who we're going to mail it to. Okay, and so at some point, we're going to have to know who those people are and be able to send that notice out to them. And so again, if you can't find it, we can come back and amend that at a later time.
That's right.
Let's see, let's talk a little bit about the information that might be required on this particular form. So this particular form looks for information related to, the estate you actually set up. So we've got to talk about what court we're in, the name of the estate, the fiduciary number, who the decedent was, and so on and so forth. So there is a bunch of information that will have to be completed, but the most important of which is the person who would actually get the notice. Who are these beneficiaries?
Right, so Virginia law requires that the notice be sent to the spouse, the beneficiaries, and the heirs at law of the decedent.
Okay, so how does the court know that that has been done? Okay, how do we let the court know that we have actually done the work that this particular statute and this form requires?
Well, the executor is required to file an affidavit that they have sent the notice in accordance with law.
Okay, and that particular form, again, I think we're going to show it on screen, is called affidavit of notice regarding the estate, and that's where you give a bunch of information about the estate, and once again, you have to then certify in this affidavit that you mailed these notices to these people at the addresses indicated. So we've sort of identified the fact that we've got to know who these beneficiaries are. If we don't know who they are, so we kind of get to the next thing is, how do we go about figuring who these beneficiaries are? How do we find them? So Jonathan, we have a will that leaves money to somebody, okay? Cannot find that person. How do we go about finding them?
Well, Richard, this actually, to me, this is half the fun of handling a probate is kind of putting together the puzzle sometimes of a family you might not be as familiar with. Usually a good starting point would be obviously look at mail, talk to relatives, talk to family, talk to friends, see what you can gather from there. You can also, of course, avail yourself of some public records. There are a bunch of websites online where you can do record searches for people. You can engage a private investigator who might also have access to some of that information. But if all else fails, there are these large genealogical research firms that are out there. Some people, might be familiar with some of the websites that are online as technology has advanced, but there are companies out there who make a living essentially identifying families and putting it together.
So once we find those people, let's just sort of continue with our discussion earlier. Once we find those, do I then have to give them notices again about what's going on?
Definitely. The court will require you to give notice of additional heirs. And it's not just for purposes of letting people know what their rights are, but from a fiduciary's perspective, to run the clocks or the limitation periods to which somebody could challenge what it is you're doing. From a lawyer's perspective, at least, the more notice you give people, the less of a chance that things are going to surprise you down the road, or after a certain period of time has lapsed.
Sure. Now, if there is no will, then we have these intestate statutes. So part of the reason, I guess, to give notice to folks who would inherit if there was no will is to see if they want to challenge a will that might be admitted to probate. Is that true?
That's just one example, is to give everybody a fair notice that you actually went to court, you probated some document or record as this person's will, and you're notifying the people that would have inherited had this will not existed. You're also letting them know that you are the responsible person, and you're identifying the local court commissioner who would be responsible for supervising this particular administration.
Okay, okay. Well, let's switch gears for a second. We've been talking a little bit about, trying to find these people, okay, who are the lost heirs, okay? So we mentioned these heir search firms, Jonathan. So, Mary Ellen, how does an heir search firm find these people? I mean, will they just get on the internet and start typing emails to people, or?
Well, they employ professional genealogists who have access to all manner of records, and they will create a family tree. They will identify the heirs of the decedent. They will locate them, and then they will provide proof documents that establish the relationship of the heir to the decedent. And those proof documents would include a variety of things: birth certificates, death certificates, census records, marriage certificates, obituaries, even ship manifests for folks that came over from other countries. So it's quite an extensive process.
So what kind of report do I get if I hire someone like that? What kind of report do you actually get delivered to you?
The search firms will always furnish a family tree. And they will also provide those actual proof documents, as I mentioned, establishing the relationship of the heir to the decedent. And if asked, they will furnish an affidavit of due diligence from
Okay.
the research.
Well, now, Marianne, you were talking about family trees. I know you were very kind enough to bring with you a piece of demonstrative evidence, if you would, of a family tree that you developed in a case that you were working on. I thought we might just take the opportunity to kind of spread that out and show folks just how lengthy it could be. You want to unfold that for us?
Yes, here's an example of a family tree from an actual case, and I know you can't read it in detail, but we just wanted to show you that there were a number of heirs in this case. This is only one half of the side of the family.
Right.
And so you could see why it was necessary to hire an heir locator firm to find all of these first cousins and second cousins, first cousins twice removed.
Sure, and you see, as we work down the little chain, as people die, then we go to the next people below them, we have to find them and so on. So
Right.
it can be quite time consuming
Yes.
and exhaustively expensive if we don't have that
Yes.
organized. I know we're going to come back to that, but I know that's a big issue that you have suggested to folks from a planning standpoint, that they want to keep that information available for people when they do pass away. What type of fees, though? We talked a little bit about affidavit of due diligence. Tell me what that is.
So that's a sworn statement from the genealogist who performed the research, and he is certifying as to his research methodology, what he did to find these folks, and that he feels that he's done an exhaustive search and that the people listed on the charts, on the family trees, are the only heirs of the estate.
Okay, and I know that we'll come back to that as we talk further, but I think that's a very helpful document if we want to go to court and ask a judge to sign off on who we can actually deliver stuff
Yes.
to. Now, clearly these folks who do this work are not a nonprofit organization. So how do they charge for their time? How are fees normally charged?
They charge in a variety of ways. Sometimes it will be on an hourly basis.
Okay.
Other times it will be a flat fee that's charged to the estate.
Okay, so those are the things we have to make sure they talk with them ahead of time, but
Right.
tend to be fairly uniform across the industry as how people charge,
Yes.
as I recall.
Yeah.
Okay, so let's talk a little bit now. We've figured out who are these missing heirs. We've located them. We have an affidavit of due diligence. Jonathan, how do we go about, do we just rely on that report that we get from the heir
No.
search firm?
It's a yes or no. It's a yes or no answer, Mr. Reddick.
You're sounding like a lawyer.
Some might say I am, but no. At the end of the day, it's really you got to use your own judgment. You know, if you're dealing with 4 or 5 family members and you've got birth certificates and death records, and you've got very clear records that these people are who they say they are, and you feel good about it, you could, in theory, just distribute. Now, an attorney is going to tell you that you don't know these people. You really want to get the court's blessing. And there is a process where you can file a petition and ask a judge to review what it is you've been able to gather and ask for his essential confirmation, a judge's confirmation of who these heirs are.
So how do you go about doing that before a judge? How do you button that down?
Like most cases, you file a petition. You lay out for the court why you're coming before the court. You know, what brings you here, what information you have. You might attach some records, and then a court would like to see that you're at least notifying people or all the people that might be out there that you might have missed of these proceedings. So typically you'll publish in a local newspaper, advertising the court date that you set to determine the heirs. And if you really want to do your due diligence, you'll also appoint what they call a guardian ad litem for interest unknown. And essentially what you're doing is you're appointing a local attorney to review everything you've gathered and to verify for the court that he doesn't see any other avenues that have been left unturned at this point. After you go through this process, this publication, you get in front of a judge and you explain to the judge everything you have, and you ask him to essentially enter a decree affirming who you believe are the heirs here.
Okay. So once we've got that done, is there another step that we want to take as far as the distribution process in order to kind of close the door and know we're done?
As in most estates, you're going to want to eventually get what they call an order of distribution entered in the case. It's not just for heir cases, but really for any case, to protect you as the fiduciary. You're gonna, now that you've established who the heirs are, you're telling the court, I'm ready to distribute the money in my hands. These are the people who you have determined, based on my petition, are the people that are supposed to receive that money, and you're getting the court's permission. Once that order is entered, the fiduciary is free to give the money over to the people who the court have identified as the heirs without having to face liability or exposure for unknown people or unknown creditors that might be out there.
Okay. So let's just say we go through all this due diligence work and we still don't know who some of these heirs are. We can't find them. Okay. So we basically have an inheritance that can't be claimed by anybody because we don't know who to give it to. What steps do we then take in order to distribute that money and get it out of our hands as an executor?
Yeah, so this is a situation where you might have a family member that you know is out there, or did exist, or there are records that this person was born, but you might not be able to locate that actual person or be able to make contact with that person, but you have a bunch of money that's for that person or maybe for that person's descendants. Obviously, you can't keep the estate open forever. There has to be a certain point where you can close it out and get the money to the rest of the people. So what you could do is you could ask the court to take possession of that particular portion of the inheritance,
okay,
and to hold it for that person in that person's name.
Okay. And they hold it for a certain period of time. Now, the money they're holding, is that considered to be now unclaimed property? Or it's in that kind of no man's land until...
Once in your hands, it's somebody's inheritance. Once you file it's something with the court and the court has accepted it, it accepts it as unclaimed property.
Okay.
And usually the court will hold it, and every circuit's a little different, but the courts will hold it for about a year before they remit it over to the state to hold in perpetuity.
Okay. Now, how and when does the executor, Mary Ellen, actually take these steps to kind of disgorge themselves of this inheritance they can't give to somebody?
Yeah, it's usually when they're getting ready to close the estate and they've really done due diligence and reasonable diligence to give the inheritance to this person, locate the person, but they've gotten no response and they just want to be able to close the estate. So they'll pay it into
So
court.
let's say the heir who we couldn't find, we might have identified who they were, but we just can't find them. Okay. How can they, is there a way for them to actually go ahead and claim this inheritance that they didn't get?
Sure, if then they decide to claim, they'll either claim it through the court if it's still in the possession of the court,
Okay.
or they can go to the unclaimed property site and claim it through them.
Okay. Now, is there a time period in which they can actually recover their unclaimed property?
I think unclaimed property in Virginia stays there forever.
It stays there forever. Wow. So there's a big number that they're holding down there, isn't there?
They have a lot of money. Not every state holds it quite as long as forever. But
Isn't that a perpetuity issue?
my understanding in Virginia is they're holding about $2 to $3 billion of value right now in other people's names. The good thing, or the positive note about that, is my understanding is that they're also using it to make interest-free loans to schools and other municipalities since they're holding it. And don't know who it belongs to.
That's good news. Now, Mary Ellen, the heir search firm, do they get involved in trying to find heirs who they know might be entitled to some unclaimed property?
No, they generally don't do that.
do not.
They may search the unclaimed property to see if the decedent had unclaimed property because it adds to the size of the estate.
Okay.
But they typically won't assist heirs with the unclaimed property claim.
Okay, so let's talk about that, though. What are some of the common issues that an executor needs to address in handling inheritance claims that are brought by search firms on behalf of an heir?
Well, they should make sure, first of all, that the assignment that the heir has given to the search firm is valid and legitimate.
Okay.
They should make sure that they're receiving the proper documentation from the search firm that establishes the relationship of the heirs. And then they should make sure that when the money is distributed, they're distributing it in accordance with those assignments to the proper heir and search firm.
Okay. So then, and we do see that they do reach out to you from time to time, and it's not a bad thing because they didn't know they were even entitled to the money.
Correct.
So
That's right.
it's a positive thing. Let's talk about unclaimed property. Now it's over sitting in the Commonwealth of Virginia tax offices, and they're making money on that. The types of stuff that we see go down there is like dividend checks, refund checks, things of that nature, right, Jonathan? Is that what typically?
It could be anything, Richard. It could be gold bars that somebody left in their safe deposit box. So if it's unclaimed and it's sitting there for a while, whether it's a bank or an executor, they eventually want to absolve themselves of it and hand it over to the state.
Well, let's talk for a second, though. I'm the executor now, and I have an estate, and do I need to do any searching to see whether or not the decedent had any unclaimed property?
To the extent that there is unclaimed property in the name of your decedent, you have a duty to actually check records and make sure that it's an asset just like any other asset. So you do have a duty to look around. I would usually say check the state the person lived in when they died. Check maybe states they might have lived in for an extended period of time before they lived in Virginia or another locality, and it's just part of finding the assets.
So I will point out to our viewers, I think we're going to show a couple of websites on the screen. One is for the Commonwealth of Virginia, where you can type in some information to see whether there's anything there in the name of the decedent. But there's one that actually covers a number of other states that are part of a network, so you can check multiple states. If some of those states are not where the decedent actually lived, and especially for military folks who move around a lot, you can see them being in multiple jurisdictions. It's worth to go back and just do a little due diligence at those various states. And generally, the process to make a claim is pretty straightforward. You know, they give you instructions when you go online. If you're entitled to something, you got to prove you're right, but they'll tell you the paperwork you have to submit. But let's talk for a second now, and kind of we covered a lot of territory here, and I know we didn't touch everything we talked about because there was just so much to go over. But Mary Ellen, how about some final thoughts or suggestions you want to point out to people who are administering estates that they should keep in mind in light of this particular topic area?
Yeah, the executors should keep in mind that they have a fiduciary duty to distribute the assets of the estate to the rightful heirs. So if they're coming to a roadblock, they can't locate people, or they think there are other folks out there, but they don't know the family. You know, people nowadays say, well, with the internet we can find anybody, but that's actually not true, in that people nowadays are so scattered. It's a global situation. They may be living overseas. So I feel that people shouldn't hesitate to reach out to heir locator firms if they need help in locating potential heirs of the estate.
Okay, I think that's good. That's very good advice. Don't be afraid to ask for help.
Yeah.
Sure. Jonathan, how about you? Some other thoughts you want to share with folks as we bring this to a conclusion?
Yeah, always check unclaimed property. Check it again. Check it a third time before you close the estate. With today's technology, everybody's opening up accounts everywhere. They have 15 different investment accounts, and they don't even remember what they have, let alone their family members when they pass away. So I've seen more than my fair share of unclaimed property claims where they didn't exist even with the state until a year or two after somebody qualified as the administrator. And sometimes you're talking about figures upwards of hundreds of thousands of dollars that just ends up with the state. So check it twice, check it for the decedent's widow. It doesn't hurt, takes you 5 minutes, just check unclaimed property.
And I know you actually mentioned as we were preparing for the show that even after you've closed the estate, it might still be worthwhile going back and checking a year or two afterwards, because again, it might take a while for things to actually get into the system, so that folks might register as being property that might be due the decedent.
That's correct. You might have finished long before a bank decided that the statute has run for them to transmit a bank account or a certificate of deposit that might have just matured. So again, it takes 5 minutes. You know, check it, doesn't hurt. If anything, you're gonna get a windfall for either yourself or for the heirs that you owe the money to as the administrator.
That's a very good point. And that's true about the banks might take a while, because I actually had one recently where they told me that it might be 2 years before they actually disgorge the money from the bank to the state of Virginia.
Of course, they won't tell you how much it is.
Well, I knew how much it was, and it was too much to be sitting around, but yeah, they were going to hold it for a while. Guys, thank you so much for coming in and talking with us about this topic. I know it seems kind of dry, yet it's amazing. It's almost like winning the lottery when you find that unclaimed property, and especially when you find out it's a check for $100,000 or more. People are very excited about it, and of course, the executors are now doing their job. That's part of their job. But thank you for coming in. Great service to the community.
Thank you for having us,
You're
Richard.
very welcome. You're very welcome. Whether your probate train ride is short or long, at the end of the journey, you need to deliver the remaining probate assets to the decedent's intended beneficiaries. Most time it is clear who those beneficiaries are, easy to get in touch with them early in the probate process, and easy to deliver what is due to them at the end of the probate journey. but sometimes it's not. Our show tonight reviewed how you go about identifying and finding known and unknown beneficiaries. And if you're unable to do so, what you should do with the unclaimed property so you can complete your probate journey. Finding and reaching a beneficiary is another reason why we strongly encourage you to sit down with a probate professional early in the administration of an estate. Proper steps taken early will make that administration and the eventual distribution to the beneficiary of the estate go much smoother. This brings us to the conclusion of our show tonight. We hope you found it helpful. Replays of this show and all the shows broadcast to date, along with other helpful information, can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.